lecture about legislative history and the problems with using legislative history in litigation. And so in another lecture, I talk about legislative history, the different things that count as legislative history before enactment and even after enactment. And here I'm going to be talking about the critiques that various people have raised against courts using legislative history. Just as a quick reminder to my students, keep in mind that courts didn't use legislative history for most of the common law era and began to do so kind of in earnest in the New Deal era. There were a couple examples from the late 1800s of the Supreme Court doing this. And then in the 20th century, it became kind of for most of the 20th century, it became the dominant interpretive method for judges. So why did people start doing this in the first place? So before we talk about what's wrong with using legislative history, keep in mind that there were reasons to do this. And one was the mentality of the judges that we should be faithful to the legislative intent. It's Congress's job to pass the laws, and we should, as much as possible, try to fulfill what Congress or the state legislature was intended in the enactment, and therefore we should gather as much information as possible about the legislature's intent or purpose. And then in addition to that, by the 1960s, courts thought that the legislature was probably relying on the assumption that courts would in fact use legislative history. There was sort of a mutual understanding, and therefore there was a concern that the Congress or the state legislatures were in fact intentionally embedding their intentions and guidance in the legislative history to direct the future decisions of courts. Now, there's a few constitutional objections that have been raised to using legislative history, and the first two are bicameralism and presentment. And so the Constitution requires that laws pass both houses of Congress and in order to become a law. And the problem is the legislative history from each house doesn't pass to the other house, doesn't have to get approved by the other house. And so it doesn't represent bicameralism. The final statutory product that ends up in our code books was voted on by both houses, but the legislative history comes from only one house at a time, and therefore the argument goes it violates the bicameralism requirement of the Constitution. Similarly, the Constitution requires that Congress present enactments to the president for signature or veto. It's an important part of our checks and balances. It gives the president at least a role to participate in lawmaking at sort of the end of the line. And the legislative history is not part of what's presented to the president. So the president doesn't have the opportunity to veto or sign off on the legislative history. So in other words, treating the legislative history as essentially part of the law violates the presentment clause, according to this argument. There's also a couple different separation of powers concerns. On the one hand, using legislative history instead of relying solely on the text allows the court to usurp the legislative function, adding meaning to what was actually enacted. And so the courts are, in other words, filling out the law using the legislative history, and essentially taking legislative history or parts of it and giving it the status of the force of law. And then on the other hand, you keep in mind that the people who want to use legislative history say that they're actually being more faithful to Congress's intent. They're showing that their use of legislative history is an expression of judicial deference to the legislature. There's also some non-delegation concerns. You don't hear this argument raised that often because of how controversial the non-delegation doctrine itself is. But the non-delegation doctrine, to oversimplify a little bit, requires Congress to be clear in certain types of statutes, at least when it's delegating authority. And frankly, a lot of the cases that we have to where we have to interpret statutes do involve delegations. And so using the legislative history, the argument goes, suggests that there's too much ambiguity for a court to determine the statute's meaning without it. And therefore, maybe too much discretion has been given to either the courts or to the executive branch. In other words, if the statute is so unclear that we need legislative history, maybe the lack of clarity shouldn't be fixed with legislative history, but by invalidating the statute and sending it back to Congress to pass one that's clear. Because in a sense, we've either allowed the executive branch, normally through an administrative agency, to fill out the meaning, or if we're trusting courts to figure out what the legislative history suggests, then we're sort of delegating lawmaking power to the courts. And so this is a special type of non-delegation doctrine that would say using legislative history has sort of an implied delegation of legislative power to the judiciary. There's also a notice requirement, and this is one of the points that Justice Scalia has brought up many times, besides bicameralism and presentment, that citizens can't predict their legal rights or responsibilities or liabilities based on the law themselves. If we're using legislative history, they have to look at murky legislative history that's not really available or accessible to non-lawyers. Or otherwise, they have no idea what the law requires of them, and this is a problem. It essentially makes the law impossible to know and makes it impossible for the citizenry to know this. This also creates democratic concerns. I hope you can see that if we're passing statutes that nobody can really know what the true meaning is without reading the legislative history, the argument goes that only lawyers will know, people who know how to get the legislative history will know what the statute is and what our duly elected representatives are doing. But the more common version of this is simply that if we're using legislative history, then the parties weren't on notice about what the law is before they got into court, and that's not fair and it creates some due process concerns. Okay, sorry for the colors on this slide. You would not believe how many times I rearranged this slide and redid it, trying to make it look okay. The Constitution, by the way, Justice Scalia really liked this argument and brought it up a lot, that he believed or viewed Congress as kind of engaged in these constant compromises or horse trading, that getting statutes passed meant the one party had to either give up some things or agree to vote for another law that the other side wanted, and so forth, in order to agree to these provisions, and that the words of the statute itself represent this compromise. In other words, the Constitution forces the main political parties, as well as the chambers of the legislature, between the Senate and the House, if there's tension between them, to reach a compromise in order to garner enough votes for a bill to pass. And the enacted text, with its ambiguity, reflects this political compromise. In other words, sometimes the law is unclear precisely because they had to make the words a little bit vague in order to get everybody to agree to vote for it. And then the concern is that legislators are kind of doing an end round around this compromise and putting stuff in the legislative history, so that years later, when the statute is actually being applied by courts, certain partisan groups will get their way, without having to give up anything during the bargaining process over enactment. Okay, then we have the friendly faces problem, and this is not what Scalia usually brings up. This is mostly associated with a famous law review article by Judge Leventhal, who compared the legislative history to walking into a crowded party, and scanning the crowd looking for a friendly face. And in other words, the legislative history is a whole bunch of just random statements that were made at committee hearings and in committee reports and during floor debates and colloquies and things like that, press conferences that congressmen held and so forth. And so any litigant or any judge could find something to support their own side. In other words, there's something for everyone. The legislative history is so voluminous and so contradictory that when courts are using it, we're worried that they're using it selectively. So you can find some great quotes from the legislative history to support your interpretation, and just strategically omit the fact that there were just as many quotes in the legislative history pointing in the other direction. And this kind of leads to another concern that's sometimes articulated without bringing up the friendly faces point itself, which is that using legislative history sort of undermines the importance of the enacted text itself, which can sometimes be ignored completely in lieu of committee reports and sponsor statements and so forth, and basically sort of fosters judicial activism. Courts can get the result they want in their case, which is unfair because the law may not be applied in the same way consistently. And so either we could have courts just using legislative history to get the result they want in that case, or you could have judges using the legislative history to sort of push their political or policy agenda. There's a more philosophical argument that's raised by legal philosophers, as you might expect, about whether collective intent is a myth. So remember, we're talking about 538 members of Congress, and so some argue that it's a myth or a legal fiction to talk about some sort of collective intent, a single intent for a body of people, when there's hundreds of people from different political parties and different regions of the country, regions of their own states, and so forth. And so some legislators may have intended one thing and some another, and some probably weren't paying attention or thinking about this law at all. And so the statements we get in the legislative history, this is partly saying they're not representative, but it's also saying even if it was, there's nothing for it to represent, that there's no sort of like mind meld of the group. And so in reality, this argument goes, we have only the individual subjective intentions of each legislator, which are technically unknowable, and that there's simply no such thing as a group intention. In some of his later opinions, Scalia, about legislative history, Justice Scalia raised a concern about the costly arms race for litigants. Getting legislative history takes a lot of time, and so and parties have to pay someone to do that, and sometimes it's lawyers, and very often the lawyers and the law firms involved will outsource getting the legislative history to private companies, vendors who specialize in this, and it's expensive. And so the concern is that each side in litigation has to compile more and more legislative history, and if it's not enough to just look until you find a quote, you have to find everything that you think the other side is going to find, so you can anticipate that and rebut it, and so forth. And so it's this ratchet effect. It keeps ratcheting up. And then Scalia brought this up when the majority in one case was using post-enactment legislative comments. And so, in other words, the Congress comes back the next session, and they're still talking about the law that passed the previous session. And so this is after the vote, or where we have a prior session where the same statute almost passed and there was extensive debate about it. And so the question is, like, how many years forward and how many years back from the date of enactment do we have to look? It seems like it never ends. And so this becomes exorbitantly expensive in terms of time and money, and therefore creates unfairness and makes the courts inaccessible to poorer litigants, or, if you would, gives an unfair advantage to parties like corporations or people, litigants like that can afford to spend any amount necessary to dig up legislative history that will support their side. And so the argument goes, it's fairer if we confine it to something like the statutory text that everybody has the same access to. There's some evidentiary or forensic problems with legislative history. And the first is whether it's reliable at all, whether it's even an accurate record of what occurred at committee hearings and on floor debates. And so so first of all, if you have a legislator who's really thought through how this statute is going to play out in the courts, they can manipulate the record to produce specific outcomes, and they even have the right to insert or amend statements. There's some notorious stories about congressmen who who had long reports arguing that the statute meant certain thing that they inserted into the legislative record moments after the final vote had been called. So everybody votes, and then we're still kind of padding the legislative history. And there is a system for kind of putting bullets or dots in the margin next to stuff that was added after enactment. But even this is a little imperfect. And so we're not completely sure. We never know 100% of what we think we see in the legislative history is verbatim what was said or what happened. And then again, the other evidentiary concern is whether the legislative history is not really representative of the discussions that took place or the larger whole. Also keep in mind that the further back in time we go, if we're looking at a statute from 100 years ago, especially the states had really, really incomplete records and spotty record keeping of legislative history. So good luck finding really comprehensive legislative history if you go very far back in time. And then what's preserved could be really skewed because it's mostly statements from the bill's sponsor or things like that, and doesn't really tell. And it could be that there was a general consensus among the other legislators that there's no real paper trail about. And then there's a concern about institutional competence. And this is an argument that most judges simply do not have the time or the resources or staff or the knowledge. They're not trained as historians they're lawyers, right? Most judges went to law school. They don't have PhDs in history. And so they don't know how to evaluate historical records and statements and interpret things in order to make an accurate, definitive determination of what the materials say about the original legislators' intentions. And so either this is going to be a huge clog on the judicial docket if judges have to slow down and take their time to work through this, and we're not even sure they're going to produce accurate, correct findings, because to be honest, judges are amateur historians, just like a lot of law professors are amateur economists or amateur sociologists or amateur legal philosophers. We like to talk about things, we have opinions, but it's not really our area of training and credentialing and expertise. And so the judges are being asked to do something that's not really a legal task. It's what would normally be a historian's task or a linguist's task, maybe, or literary expert, to kind of piece together and figure out what's the accurate record and what does it even mean. And so maybe in our second best option, which is just focusing on the statutory text, is our best option, because we know that judges can take the law and they have legal training and they can provide legal analysis, but the legislative history is not a legal question, it's a historical question and a documentary question. And that's outside the training and expertise, and also just the time constraints and resources for most judges, especially our state court judges. And that concludes our lecture about our concerns about and objections to legislative history.